Welcome, everybody, to the Ross Report. So good to have you with us today. We're going to give you an update on the Vermillion Parish situation, the school board. Oh, my Lord, yes, they're up to their old tricks. And also, we're going to give you an update on this charter appeal. And Mr. Lane Roy is the attorney on both issues. So, Lane, welcome to the Ross Report. Good to have you with us today.
Thank you again, Carol. I appreciate it very much. One thing I thought about as I was waiting, I think that your husband and my longtime friend, Ron Gomez, may be wondering about us. We spent so much time on the phone recently. Tell him that it's all business.
Well, hey, he's listening, believe me. No problem. He's listening. So, Lane, I want to get an update on that Vermillion Parish situation because it seems like it just never ends. It's like history. And by the way, does this remind you of a little situation that you're still fighting that happened many years ago in the Lafayette Parish school system? And here it's happening. Yes, it seems like history repeating in Vermillion Parish.
It is, Carol, and for people who haven't watched it for the long term, the motive behind the Cooper matter and the motive behind the Superintendent Pio in Vermillion Parish is exactly the same. Boards throughout Louisiana who have been advised by Attorney Bob Hammonds of Baton Rouge, and he represents about 40 of the boards throughout the state, have decided and have put into effect the proposition that even though Act 1 of 2012 gave to the superintendents much of the authority that boards had for many years before that, in fact, just changed it around, that the boards decided after they fought unsuccessfully through the Supreme Court to get rid of Act 1, that what they would do is they would make the use of Act 1 that legally gives authorities to the superintendent rather than the board. They would make it so unpalatable to use that the superintendents wouldn't use it. So, in effect, they're reading out Act 1. They threw Dr. Cooper out of Lafayette. They're doing their absolute best to get rid of Jerome Pio over in Vermillion Parish, and he's done nothing but an absolutely fantastic, unbelievably good job in that parish, and nobody disagrees with that. Even the board doesn't say anything other than he's done a great job. But the plan is they want to get rid of him. As I've said before, he could be Mother Teresa reincarnated. They want him out. And they not only want him out, they want to trample him like roadkill so that he will be unemployable anywhere else in the educational system.
Wow.
And that's what they're going to hang on the fence for other potential superintendents to say, if you comply with Act 1, we will crush you.
Well, frankly, the Supreme Court has pretty much weighed in. Now, the confusion was caused by some parts of Act 1 being overly broad in terms of teacher tenure and things like that. But they were very specific about the duties of the school board, which include budget and policy setting. That's it. Not micromanaging and not usurping the power of the superintendent to manage the system. So what don't they get? What don't they get?
They understand that, Carol. They just will not comply with it. And so we had a school board meeting in Abbeville, a regular meeting last week. I'm sorry, it was a special meeting last week. There's another special meeting tomorrow night because they did not properly notify the public of some of the things they wanted to do last week. Bob Hammonds was there. And the proposal tonight on the agenda is two main things. The board wants the superintendent to fire its in-house attorney, who also is its risk manager, and who has done nothing but an excellent job. He's a fine lawyer. And then the board wants the hiring of Bob Hammonds as the new attorney. So it all comes to fruition tonight. If the superintendent decides he's not going to comply with their wishes, and only the superintendent can terminate, only the superintendent can hire, then they will take the position that he's disobeying their orders, and they will seek to use that as an attempt, another attempt to terminate the superintendent.
This is so reminiscent of what happened with you and the Lafayette Parish School Board, where they weren't happy with you, what you were doing, advising them properly. So they fired you, and they brought in an assistant district attorney to handle.
They did, and he did a fine job for them, an excellent job. But you see, he was telling them what the law was rather than what they want to do. And the same thing is happening with this attorney in Abbeville now. Woody Woodruff represented him for 10 years. Woody is a 50-year friend of mine, a fine lawyer, honest, upstanding, and he finally quit. He said, I had enough of this because these people don't want a lawyer. They want a yes man, and I'm not that. The superintendent hired a lady over there. She was a fine lawyer, did a good job. She quit after just a few months. And now we have another attorney, and they just want to get rid of him. They want the superintendent to have no honest legal advisor, and they want someone in there who they know will tell them whatever they want to hear, so that it doesn't matter what the law is. I sent them a letter about 2 hours ago reminding them that the lawyer they want to hire has cost Lafayette, before they ever paid Dr. Cooper a dime, almost $2 million in defense costs and his representation, and has just cost Rapides Parish $2 million to pay off a teacher who was politically hatcheted out of her position and who won a case after 13 years in court. And Bob Hammonds was the lawyer. He has the same modus operandi. He comes in, he advises the board, he gets his former law partner in there to do an investigation, then he gets a friend of his to come and act as the hearing officer, and he's millions of dollars into his pocket over the thing. The board is out over $2 million. This poor lady who was a champion in terms of a teacher, won all kind of awards, is booted out because of political reasons. She's in a shambles now. She went broke. She's been in bankruptcy, and it's going to cost that board up there another $2 million to pay her off. Now, who comes out ahead on this?
Yeah.
It's not
Nobody.
the board. It's clearly not the teacher. It's not going to be the superintendents. It's one person. And I have a major problem with that. Lawyers, or even trial lawyers, and for what I've done for 50 years, litigation ought to be the last resort, not the first resort. And it should never be something that is done to promote the lawyer's interest. It ought to be the last resort for the client's interest.
Why does it seem?
Just not seeing that.
Why does it seem school boards always have these sorts of problems? Is it just because they're so used to meddling, and now this transition into not meddling? I don't understand. It seems to be. It seems to be endemic in Louisiana, and not even since Act 1. I mean, it goes back even farther than that. I don't get it.
As you know, I represented the school board here for, I think, 26 years.
Right.
And have seen many meetings as well as going to other school boards. Your observation, I think, is correct. The lower the office, political office, such as parish representative or city representative or the school board, then what happens, I believe, is that the salaries are not very high. And the people who run for them frequently, certainly not always, but frequently, are people who decide, I at least am going to be able to control things. I'm going to get my way in this job.
Right.
And you know what? They are spending our tax dollars, our hard-earned dollars, in representing an organization and acting on behalf of an organization in charge of our children and grandchildren. It's a huge responsibility, and some of them take that really to heart, but others just decide, I'm going to do whatever I want to do. I'm going to follow the good old boy network and hire whoever I want to hire as the bus driver or the janitor or the teacher or whatever it might be. And it's just wrong. And when Act 1 plainly said, you cannot do that, it is illegal, is stuck in their craw so badly that they decided, I'm going to bite everything that comes around me, even if it means the decline of the system.
Well, it's crazy because it doesn't seem to me that these school boards have a lot of money laying around to waste on things like this. And
Nobody
didn't
does.
the board president in Vermillion got so frustrated he resigned?
He resigned, and I didn't know the guy, but he attended a number of meetings. He was a very nice person. He was, I think, well-intentioned. He was on the board, a local businessman for all of the right reasons. He finally just gave up, I think, between himself and his family. They told him, you just go home. But that's part of their modus operandi, I get. If they make it bad enough.
Wear everybody out.
It's right. It's like going to fight with pigs, Carol. If you don't like to get dirty, you better not fight with pigs because they love it.
I wouldn't say we're fighting with pigs, but we have another issue that we want to take up, and we know a lot of people are interested in the update on the charter lawsuit. Speaking of, getting down in the dirt and having to fight it out. And I'm not casting aspersions on anybody. It's just an absolute difference of opinion at many levels. So we want to get to that. We have to take a break. Lane, I'm so appreciative that you can stand by and give us a little update on the charter situation because we get calls all the time. Where does it stand? When is the court going to hear it? When's the Court of Appeals going to be heard? And, of course, I've received a bunch of documents from you today, so we'll discuss those and give everybody an update when we come back. Elaine Roy talking about the unfix or the fix of the charter or the fix of the fix or whatever it is we're going to be doing. We'll be right back on the Ross Report. And if you have any questions, 232-1542 on the Raider Solutions Hotline. Don't go away. Lots more to talk about. Welcome back to the Ross Report. I'm just reading on the crawl on Fox News. Mueller says now the investigation is over. He's closing his office and resigning from the Justice Department. What took you so long? It's about a year and a half too late, Mr. Mueller. Okay, Lane, back to the real world here. Anyway, okay, now we're talking charter appeal. And so the three documents I got, one was the request for a stay pending appeal. Another one was the Secretary of State's response to the objection filed by some of those residents for the suspensive appeal. And then, of course, the memorandum in support of the stay pending the appellate review. Let's go through this because the stay pending appeal, you were asking originally for a devolutive appeal rather than a suspensive appeal.
That's correct. That is correct. We did ask for a devolutive appeal, and the reason is that we suspected that the Secretary of State would ask for a suspensive appeal. And because the law provides that a public official does not have to put up a bond for a suspensive appeal, a private individual does. So we believed, therefore, that if the Secretary of State appealed it suspensively, it would suspend the judgment just as if we had done it, but we wouldn't have to bond it.
Okay.
And that's where we are now. The judge will have to decide whether to grant the appeal as suspensive. It so happens, Carol, we had this identical issue a matter of 2 weeks ago in Abbeville, believe it or not, with the school board, where the judge denied a suspensive appeal to the superintendent on an issue with the school board. And we took that issue up. He made it the devolutive appeal. We took the suspensive nature up to the Third Circuit Court of Appeal on an emergency writ, and the Court of Appeal agreed with our position and just advised the judge to grant the suspensive appeal, saying, you've got to come up with a legitimate reason to deny a suspensive appeal, and the fact that you just didn't like it is not a good reason.
This was really interesting. Also, in the request for stay, this is the part that got my attention. The court's ruling denying the claim of unconstitutionality effectively declares that the ordinance is viable and constitutionally sound, and that the Secretary of State is bound to give the ordinance effect in preference to the Home Rule Charter, even though the provisions of the Home Rule Charter also remain in effect. What a mess! I mean,
it is correct. And for that reason, we think that there's no legitimate reason for Judge Trahan, in my judgment, to deny a suspensive appeal. It's our firm belief that we have a very short return date on this appeal, June the 6th now. It's the date by which the record is supposed to be prepared to go to the Court of Appeal. It can be extended, but in this case, we think they'll probably meet that date.
Yeah.
And as soon as that happens, they'll ship it to Lake Charles, and we think the court will look at the matter in a very quick time frame. I think, Carol, there's every reason to believe that by the end of June, we'll have a decision from the Third Circuit.
That would be great, because I think there are a lot of folks who are just waiting in the wings to get this settled. But, you know, I thought another part that was very salient. Unless stayed, the judgment is likely to result in an unconstitutional and illegal election with disastrous consequences for the Lafayette City Parish government and its voters. And I think the Secretary of State made that point. Going forward, should the court's judgment be overturned on appeal after candidates qualify and run for and possibly are elected to office, Lafayette government would be thrown into disarray. So it would really be a mess, and it would cast, I think, in doubt anything in the future that would happen. Any issues that come
clearly, I think, would do that. And you see, the Secretary of State, just like the clerk of court, but even more so, has the obligation under state law to certify an election on a local basis if it's appropriately done. In other words, he couldn't certify an election if he thought they hadn't advertised it, or he thought that people had been locked out of the voting booths, or that sort of thing.
Right.
He couldn't certify it. And in this case, he has already told the local officials in Lafayette that what has happened here is not legal. And therefore, how can he, if they go forward with this election in August or October, how can he certify it when he's already determined it's not legal to do so? So they have an election, everybody spends money, we go out to vote, advertise, etc., and all of a sudden he's got to say, I'm sorry, it's still not right, and therefore it doesn't count.
Well, the thing that frustrates those of us on the other side who are appealing this because we think it's been wrong from the beginning is the fact that folks knew way back when that there was a problem, and yet allowed the original to be certified, the original vote to be certified, knowing full well that there were problems. And to be honest with you, several of our group have made a request to consolidated government, asking for the maps, asking for the descriptions of the precinct line, where are the precinct lines, et cetera. And apparently those still have not been determined. So what did they vote for? When they passed that ordinance, what exactly did they vote for? Did they know?
It's one of those deals, Carol. If you look between the lines and even look at testimony from some of the city parish witnesses at the trial, there was no map before the election. It did not exist in final form, and it still does not. So what that means to me is that we voted on a principle, even though the charter says that the specifics are part of the vote. We voted on a principle, and they fill in the blanks. Mm-hmm. That is never what a constitution does. Never.
No, because you and I have talked about this before. You do that, and then a vote of the people is nullified anytime the council wants to nullify it by an ordinance. By ordinance.
Exactly.
And it doesn't matter what the issue is. Listen, we have to take a break. I want to talk to you about going forward, because there are some folks who are just bloviating about what happens from here. It's going to throw everything into disarray. But I think there is an answer, and I hope it's presented to the Court of Appeals. We'll be right back on the Ross Report with Lane Roy, attorney for the plaintiff Keith Kishbaugh, and those of us who believe that the charter wasn't fixed in any way, shape, or form. We'll be right back on the Ross Report. If you want to get into the conversation, 232-1542. Don't go away. Bumper music there. Welcome back to the Ross Report, everybody. We have Lane Roy, attorney for Keith Kishbaugh et al. Versus the City of Lafayette, Parish of Lafayette, City Parish Consolidated Government. Anybody else we can sue, we will. Anyway, Lane, welcome back. I want to talk to you about this, the response to the objection to the suspensive appeal, because they've said they don't want it suspended. But how can it not be suspended? How do you go forward with something like this when you're saying that that this is, as the Secretary of State said, this is a special case. It's not an ordinary case, and the judgment rendered by the court is not an ordinary judgment. Explain that thinking. Why did they think that?
Well, the situation here is that the city parish plans to go forward with this upcoming election, even though there is an appeal of the judge's decision. What that means is that they're inviting everyone to go forward as though the challenge had never taken place and as though the appeal is not going forward. What happens then to the people who put up monies to qualify, put up monies for advertising, raise monies from friends, relatives, and people in the community, and put up signs and so forth? If they do that and it was for naught, what happens then? What happens if the people go to the election and the election was for naught? We've got too many elections already, and doing all of that when it's preventable is to me is something that just it shouldn't happen. The city could simply say, in view of this pending appeal, we're simply going to postpone these elections pending the outcome of the decision. And I think that's what ought to happen. Otherwise, we take the chance of costing a lot of people a lot of money, a lot of time, a lot of effort, and the voters a lot of interest in this election. It seems to me that what has happened here is that this timeline that the city parish is trying to enforce and putting aside the appeal is something that promotes those who are already in office versus those who are trying to think about running for office.
Yeah, and no matter what happens going forward, I mean, let's say the appeals court does grant the suspensive appeal. Also, here's the case timely, says that this was all done improperly. The ordinance cannot stand. It has to go back to a vote of the people. In that case, since it cannot be voted on again, this issue cannot be voted on again within a year, would not the same district lines apply, the same form of government that we have now, and the same term limits? Would that not still be in effect?
I believe it would, because the new form of government that the people approved in December of 18 does not take effect, except that's what's necessary to set up the election, until after the election and the swearing in of the new council members, city and parish, and the new parish president and mayor of the city. So we do not have the new form of government yet. And you're correct about that. We would really be in limbo then. Everybody would be trying to figure out, do I stay on in office? Do I have to get out of office? Do the term limits apply now? Am I running past the term limit and violating the law? We've created here as big a mess as could possibly be under the circumstances. And it's unfortunate because it's a time that the people have expressed their will, and that will ought to be put into effect.
Yes, legally voted on.
Correct.
I think it's interesting because also in farther on in this response to the objection to suspensive appeal, the Secretary of State understands that the present City Parish Council is fearful that further amendment of the charter, if put to the voters, might fail. However, the charter belongs to the voters, not the present council, half of whom will not be there. The judgment in this case gives the decision.
I thought that statement was 100% correct. It was a good statement by a fine lawyer whose area of specialty happens to be this, and it reminds me of the fact that we hear it less today than we used to, but the government works for us. We don't work for the government.
Right.
The government serves the people. The people don't serve the government. And we too often, this day, we see the reverse coming back into effect. Ronald Reagan would roll over if he saw what was happening here.
Oh, forget Ronald Reagan and the founders. Good Lord, they never envisioned anything like this. We've given too much power to the administrative state and to the legislative state. I think it's really telling. They say the judgment in this case gives the decision that the Judge Strauss on the contents of the charter to the council in preference to the voters, and that goes back to what we were just saying. That if the council wants to suspend any action of the voters or override any action of the voters, all it takes is a majority vote of the council.
It's exactly right. When we had the trial, when Mike Hefter was testifying, I have a copy of the transcript. In part of his testimony, he said he had an email from the council representative, and this is shortly after the December election, which said, suggest we do not want to change lines now as new ballot would be required.
Yes, indeed.
Wait until all in place and then do it by ordinance.
Yes, indeed.
Okay.
I quoted that on my show a couple of weeks ago because to me that was like the smoking gun when I read that.
Agree.
Yep.
I agree.
They
and
knew
Mike,
what was
Mike
going
said,
on.
well, I didn't agree with that, but that, you know where that came from? That came from the city attorney.
I'm telling you. Well, now today in the Advocate, there's this. Well, I think it was online last night. Lafayette residents object to appeal that would leave them disenfranchised.
Yes.
How is? I mean, if this is overturned and we revert to what is existing now, they're not disenfranchised. The current lines count these people. They're in the current precincts. It's the new precincts that they're trying to push.
The lines before the December election had them in proper order. Everybody was fine. After the December election, it was determined within about 7 days that they were not anywhere because, as we are well aware, in order to create a precinct, you've got to have 4 sides at least to it. You've got to close
Yes.
the 4 sides.
You got to know where the boundaries are, right?
That's right. And there were 3 boundaries only. So the last boundary did not exist. And so per the local registrar, as well as the Secretary of State, those people, and it's about 340 people, cannot now vote, and they cannot qualify for office, can't run for office. And this is, I can see these people from my office window right now. I lived on the street that these people are complaining about. And so this is a real problem. It's a substantial, real problem when an error like this disenfranchises some of our neighbors. And this is what the judge said. Well, it's kind of just a little clerical error. I don't think it is to them. You know, we had people who fought and died for our right to vote, and we try and get people out to vote all the time because it's one of our most precious rights.
No kidding.
We've disenfranchised these people and told them you can't only not vote, you can't run for office either. And it's not a big deal. I think it is.
Oh, yeah.
This is a real, Carol, I look at this whole
Hey, we didn't do that. They did that. We didn't do that.
Exactly.
They did it by
That's
screwing up the
exactly
precinct lines.
That's right. We want to fix it. We didn't cause it. We simply want to fix it correctly. And it's got nothing to do with politics. We have a great community here, and if we don't take some action to try and take care of matters such as this, our community will go down, and we don't want it to do
This
that.
is pretty basic. Okay, let's give them the timeline. So on June 6th, there'll be a hearing on this suspensive appeal.
The June 6th is the return date by which the local record, which would be the transcript, which is already prepared, copies, the clerk has to make 2 copies of everything to ship it to Lake Charles.
Okay.
And by that date, he should have everything ready to send to the court in Lake Charles. He'll call them and tell them it's on the way. He'll overnight it to them. We should get notice from the court the next day that it has been docketed there, the correct number for it, and what the dates are for briefing the issue. I think they're going to set very short dates. Normally it would be 30 days per side, but I believe it's going to be much shorter than that because of the nature of the case. And they will set it for a hearing before a panel of 3 assigned to the case of all of the judges in the Third Circuit.
And surely by now they know it's coming.
Well, they do. They've been notified. They always have an emergency panel on standby, and so they're there. We'll have people available for it, even in the summertime when people on vacation, etc. There's always an emergency panel available.
Okay.
So the chief will impanel a panel of 3 to make the decision, hear argument, and render a decision.
All right. And before we wrap up, what on the Vermillion Parish issue, where do you go from here on that?
Carol, the matter there is so close to disaster that we're considering even filing an injunction to prevent the board from ordering the superintendent to perform illegal acts.
My goodness.
At the peril of his job at the peril of the job of his chief legal advisor, at the peril of the entire system in Vermillion Parish, which is on the cusp of the biggest economic development and biggest social development the parish has ever had, and is one of the top 4 schools systems in the state.
That's the crazy part. He brought it to an A, and they're punishing him for that. That's crazy.
Absolutely. It's just amazing. It goes along with the old saying, if you went to Angola and unlocked all of the doors, there's a substantial percentage of the people who would stay there simply because that's what they're accustomed to.
Yeah.
And I think that's what we're seeing here. It's a shame.
So they're trying to put him in a box, getting him to do something illegal, and then saying, well, you did something illegal. Well, I did it at your command, but that wouldn't matter.
Exactly, and then they want to fire him for it. I'm telling you, the guy has more gumption, more assertiveness than I've ever seen in the superintendent.
Well, and I think he has the right attorney for that, and I think we do too. Thank you, Lane Roy, for all the great information today. Keep us posted, whatever happens on whatever issue. You are a busy man, I know. Well, we appreciate your time.
Carol.
Thank you so much. All right, Lane. Thanks so much.